Okay, welcome back. And if you're just joining us, we're looking at the topic of the tribunal sacking the Nasarawa state government, Abdullahi Sule of APC, and instructing INEC to withdraw his certificate of return and issue same to the petitioner, in this case, PDP's David Ombugadu. It was a split decision. The chairman of that particular tribunal, Justice Ezekiel Ajayi, and Justice Chiemelie Anaga, they were the majority component of that decision. But the dissenting judgment was delivered by Justice Ibrahim Mashi, who says that the PDP's case lacked merit and failed to prove what they were indeed demanding, and upheld INEC's decision. Now, Dr. Mubarak Adekilokun is our guest in our Abuja studio. I don't know if you wanted to comment at all on the point that that last guest before we went on break made, that is George calling in from Ikeja, that he seems to be concerned that the courts, and I've heard lawyers or even knowledgeable people who aren't necessarily lawyers, when they are having these kind of conversations, have been concerned, are apprehensive that the court system is taking far too much of far too much of a role in the decision of our petitions, and he feels that it is worrisome. I don't know, without prejudice, do you have any impressions one way or the other on that particular point?
What I only have to say, because he commented especially in relation to what constitutes overvoting. The Supreme Court has settled it clearly in the case of Oyetola and INEC, that for you to be able to prove the allegation of overvoting, you need three things. You need the BVAS machine, you need the voters' registers, and then you need the result of the polling unit, which is even far more reasonable. In the electoral, they only said accreditation based on BVAS and the polling unit results. But the court has said, these BVAS computers, they are susceptible to errors. I was part of the team at the trial during Governor Adeleke's petition. One of the major issues raised was that if you use a BVAS machine, for example, in a village that doesn't have internet, it is until you click the send button before the figures will have to go into the back-end server. Now, let's assume that you did it in village A that has no network, because these things work with network. You did it in village A, it is until you get to where network is. And it is possible you don't get network the following day, and you have to submit the BVAS machine itself to INEC. So it is possible that some BVAS machines will be submitted without sending the particulars, the total number of accredited voters, into the server. So they are susceptible to errors, technical glitches. And that's the reason why Supreme Court has said, don't only base determination of what overvoting is on BVAS machine, because by the name, it is just a machine, can fail at any time. So also look for what we also have to tender what we call the voters register, which we have been using before. Those are registers. It should be shown whether the total number of registered accredited voters were ticked on that voters register. Then you also have to look at the EC8A, which we call the polling unit results, because it is in that result that you get how many total valid votes, total rejected votes, and others. So you have to match them or compare them with the total number of accredited voters you have in that your BVAS machine and the voters register. So Supreme Court has settled it. So it is no longer whether National Assembly says something, Supreme Court says something. And what the Supreme Court has said is even far more reasonable. So this has been settled judicially in Nigeria, that for you to prove the allegation of overvoting, you need the BVAS, you need voters register, then you need what? The EC8A result of the particular polling unit.
So you and your party, APC, you take you differ with the chairman who, I just spoke about, Justice Ajayi. You differ when he declared that Mbugadu provided the results of the various polling units and forms EC8A and proved to the tribunal that the results were manipulated in favor of the APC.
Of course, definitely we differed. We tendered barrage of documents too, pointing towards the fact that Governor Sule won this election. That it was not Emmanuel Mbugadu that won the election. And it's their wisdom. If you read the dissenting judgments, these facts issues were critically dissected and analyzed by Honorable Justice Machi. If you look at the majority judgments, they only made some references to it. At the end of the day, they entered judgments completely for the petitioners. Let me tell you one very important point, which will also constitute our grounds of appeal, is that the tribunal in its majority judgment says PDP won, Mbugadu won with 293,287 votes. That's after the entire addition and the subtractions. Mm-hmm. And then Governor Sule won with 292,446. If you deduct this from the PDP votes, you'll be left with a margin of 841 votes. So from the majority decision of the tribunal now, which is the law, that David Mbugadu won with 841 votes. Now, the tribunal nullified the results of 4 polling units based on overvoting. 4 polling units. These are Boha Serki in Akwanga, Kofa Magaji in Nasarawa, Gadabuke and Ihampe. The 2 of them are in total local governments. If you look at the total number of accredited voters of these 4 units, it gives us 911 votes. 911 total number of accredited. Whereas the margin of win, of lead, as described or as declared by the tribunal, between PDP and APC is 841. Where do you put or keep the margin of lead principle? It is there.
Okay. Let me bring in...
Sub 3.
Let me bring in Mr. Lalekon, I beg your pardon, who has called in from Ikorodu and indeed has held on for a while. Thank you very much, Mr. Lalekon. Go ahead, please.
Okay. Hello?
Yes, good morning. We can hear you. Go ahead, please.
Okay. Good morning, sir.
Carry on, please. Don't listen to the feedback, the echo. Carry on, please, Olalekon.
Okay, good morning, sir.
Good morning.
I've been hearing all what our lawyer have been saying and Uncle Yari. The only thing here I want to add to is that why can't you just forget about using BVAS during the election? Since the election we are doing in Nigeria now is not transparency. You understand? We can just go back to option A4, the one we did during the SOFA and MKO. Because the election in Nigeria is not transparent to anybody. Why can't let's go back to option A4. Then there'll be no going to court after election. You understand? Because all these things, the lawyer said they want elections to be nullified and they will be collecting money from all those people. Let's go back to option A4.
Okay.
Whether you are voting for AB, then you just line up. You just line up. Immediately everybody will know their results. Nothing like BVAS or this thing.
Okay.
The only thing I think this Nigeria, they are not transparent with any election. Let's just go back to option A4.
All right. Thank you very much for your contribution, Mr. Lalekon in Ikorodu. Well, the train has left the station and people seek to improve, and I think that is the. But let me allow the lawyer, Mr. Kilekun, respond to that. That's ancient history. We can't go back, can we? But I think Olalekon was relating intricacies that we now have to contend with, and probably saying that life used to be a lot simpler at a certain time.
I think, like he said, some members of the National Assembly who are the lawmakers are also hearing us. Maybe in case they decide in future to amend the provisions of the Electoral Act. There have been series of arguments for and against the adoption of option A4. I also remember that when I was young during MKU's regime, I was part of those that went to visit even though I was less than 18 years then, where elections were being held, and it was very interesting. So it's a matter to be decided by the National Assembly whether there is any need for Nigeria to adopt the option A4. But now, what we have is the secret ballots. That is what is still being used in Nigeria for now. So as I was saying the other time, that Section 51, sub 3 of the Electoral, I have the Electoral Act here. I don't want you to look as if Dr. Adekileku is manufacturing some provisions of the law. It provides that where an election has been cancelled, let me read it out. Where the result of an election is cancelled in accordance with the subsection, that's subsection 1 of Section 51 on overvoting, said there shall be no return for the election until another poll has taken place in the affected polling units. Assuming without considering that there were overvoting in those 4 polling units. And we have seen that the margin as declared by the majority tribunal is 841 votes. The total number of accredited voters in those areas is 911 votes. The total number of accredited is far more than the margin of lead between the two. The Electoral Act said there shall not be any return. The worst is for the tribunal to say, go back to these 4 polling units to go and conduct a rerun election to now fully determine who has won the election between David Ombugadu and Governor Sule. The tribunal also glossed over it. They didn't even say anything about it. These are part of it. We have seen situations in Nigeria where rerun has been held. Tribunal can declare, go back, since we have cancelled the election in 4 units as a result of overvoting, and the margin of lead principle has squarely come in. Go back and do rerun election because you only have 841 margin between.
But they didn't so declare.
Bugadu that has been declared.
And these are part of the things that you are contending. Good morning, Ahmed in Niger State.
Good morning.
Good morning, sir.
Good morning. Dr. Mubarak, good morning.
He can hear you. Please continue.
So, I don't know. Nigeria now, my contribution goes to that. Judiciary want to take the position of INEC now. Because in Nigeria, we don't have a constitute body again. I think that the judiciary only interprets, not to decide. It's just to interpret the law. But we don't know. Look at the cases of Kano now. It has come to a fumble that the judiciary don't have a sanctity, a judgment that would be relied on. I beg, and Dr. Mubarak, I don't know. Nigeria, we are fed up with judiciary. They should rethink. Otherwise, if not, judiciary have messed up what you call a hope of ordinary man. Because if INEC have taken a decision, this position of INEC and the Electoral Act testify that along the line, judicial intervene want to take what belongs to INEC or the position of INEC. Oh, that is what's bothering me.
All right, then. Well, thank you very much for calling in. But let me just say here that in reacting to the decision of the tribunal, Mr. Ombugadu's lawyer, Mr. Johnson Usman, SAN, he actually lauded the judgment and quite frankly, he was pleased with the fact, he said that this proves that the judiciary is the last hope of the common man. That was his position. You might say that, of course, now, necessarily, but I'm just saying. Now, I wanted to ask you, as a lawyer now, the concerns that are being brought up, it might not necessarily, it doesn't have to refer to this case, but the point that Ahmed from Niger State made, that the tribunals, the judiciary is not to decide, it is only to interpret. As a lawyer speaking to non-learned people, what would be your comment on that particular assertion of his for education?
Well, you know, the primary role of the judiciary is to adjudicate. That's what Section 6 of the Constitution says. When a legislature has made the law, if there is any dispute between either any of the agencies or layers of government or individuals or among individuals inter se, and you have brought a matter before the judiciary, they interpret the law and give effect to it. And interpreting the law, whatever conclusions they have come into, that is also the law. Like the Oshun that we are talking about now, the Supreme Court in its wisest, in its wisdom, has stated that even though accreditation has been referred to in terms of the beavers only, the reason I just explained to you that there could be technical glitches, is it not substantially enough for the Supreme Court to say, voters register is also very cardinal, because that is the manual that we use up to today or to tomorrow. If you base determination of what constitutes accreditation only on beavers, it is possible there is no server. It is possible that the copper that was appointed as the presiding officer had even submitted the beavers machine to INEC without uploading.
Okay.
And you have gathered a lot of voters to come and vote in a particular polling unit. They have wasted their time from morning till almost evening time. So that's why Supreme Court has added. See, these decisions are, in most cases, very reasonable. That instead of leaving it only to be determined by the beavers, why not also use voters register? So if you know that you want to contend that there is overvoting in a particular polling unit, there is nothing bad in you to get the beavers, voters register, and the polling unit results. So it's so simple. So it's not only that the Supreme Court or the court, the judiciary interpret the law. They interpret the law, and in the process of interpretation, they arrive at firm decisions, which will now constitute the law.
All right. Okay, let me bring in Emmanuel, calling in from Jigawa State. Good morning to you, sir.
Good morning, sir. Good morning, doctor.
Okay. Go ahead, please.
Okay, I want to contribute towards the election, what happened in Nasarawa. I think the judge have actually done justice to this. Because the lawyer is talking about the ground. When we are talking about ground of election, by the Act of 222, it stated that election collects from polling units. I think the petition have proved enough by tendering the result from polling units, from IRED, from Beaver. They have proved their case beyond doubt. So they have actually won the election. What the Tribunal did is the justice for the masses of Nasarawa State. We will not be comparing the election that happened in Nasarawa with Kano. It's far different. And what happened in Osu is far different. If you are in Nasarawa State, you actually know that what takes place, PDP have actually won the election in clear terms. It's just that overvoting in Gayam watch, overvoting in Chiroma watch. If you look, the House of Assembly election and the governorship election was different entirely. So in time of justice, this is an open justice to the masses. So I think that the APC or Governor A. Sule should accept defeat. Going to appeal is waste of resources of Nasarawa State.
Indeed. Well, thank you very much for calling in. As I was saying, the lawyer to the petitioner has seen it the way you have seen it, but then the law is arranged in such a way that you have another opportunity. Should you be in disagreement with anything, take it up to a higher court where it shall be pronounced upon. But thank you very much for calling in, Emmanuel, who was calling in from Jigawa. Okay, interesting, because Justice, in case you've heard about it already, but it was Justice Ezekiel Ajayi, who was the chair, and Chiemelie Onaga, who had given that split decision, saying that the Governor Abdullahi Sule of APC, should vacate the seat, and indeed INEC should withdraw his certificate of return and hand it to who they had adjudged to be the winner of that election. And Justice Ibrahim Mashi III was the only one who saw it differently, and so we have a dissenting judgment, which I have read that APC in Nasarawa is in full agreement with, but this now has to be tested when you take it forward. And I'd like to thank very much our lawyer, the lawyer on our program here, Dr. Mubarak Adekilukun, who has been explaining it to us, and also there's not very much need to, because the lawyer for who the tribunal has now given the decision to, he's always said that the judiciary is the last hope of the common man, and this indeed is as he wanted it, but not so, say, those who will be appealing. How much time, when will this be decided now, when you take all of these that we've been listening to from the beginning of the program, when will this now be taken to a higher court?
And the law is that we have 21 days within which to appeal, and then as soon as, I'm sure the notice of appeal is ready, it will be filed. So the appellant now have 7 days within which to file brief. Respondent has 5 days. Appellant has 3 days within which to reply. And it is the sole discretion of the President of the Court of Appeal to constitute a panel to hear. So we can really not say when it will be heard. But the Constitution has given the time frame from the date of filing of your notice of appeal to the date of delivery of judgment. You have 60 days maximum. The Supreme Court has described it like a rock of Gibraltar that cannot be shifted. You can't move a day outside of these 60 days. So certainly, as from the date of filing of the notice of appeal, you have 60 days within which the Court of Appeal shall determine the appeal of the appellant.
And all that while, Governor Abdullahi Sule of APC is in place, right? He's still in place, carrying on his duties.
He is fully on ground in the office and continue doing all his developmental projects in the states.
I want to thank you very much.
After 21 days, yes. Thank you.
Thank you very much, Dr. Mubarak Adekilekun, for explaining the case to us. All right, then. So that's our program today, and please join us tomorrow when we shall have another topic for consideration. Until then, I am Yori Folani. Bye-bye for now.